Now that is just a disclosure about that. Now, another thing which I just wanted to mention is that I've been listening to the other speakers. I have also been an ex-banker, and as a banker, I have seen things change from the physical banking system to the digital banking system, then the virtual banking system. Now people are talking of crypto banking system, and then of course death of banking system. If it continues, we will definitely see the death of banking system very shortly. I hope the cryptocurrency craze, if it is regulated, when I say regulated, there is no solution but to ban private cryptocurrencies. Otherwise, we should be ready for a situation where government does not require anybody to hold taxable assets. We all will convert our bank deposits into cryptocurrencies, and we will all enjoy. And instead of being legally, law-abiding, tax-paying citizens, we will all become non-tax-paying citizens. Once we do that, banking system will no longer be there. Why I'm making a mention of this is technology is like a very enticing thing. Okay, it is attractive, but we need to actually put some self-discipline on ourselves in the use of technology. This translates into cybercrime related issues, and now we will be also looking at the data protection related issues. Now, as fraud examiners, you very often come across situations where because of the fraud, there is a wrongful loss which has been caused to an honest person, honest company, and there is somebody who is enjoying the benefits of the wrongful gain. And we are all trained to ensure that our contribution to the society is to weaken the person who is a criminal and strengthen the hands of persons who has been wrongfully victimized. So this is basically the fraud related mindset, fraud examiner's mindset. And in a normal case of a fraud, normally you will come across a situation where a fraud is reported. When we say fraud is reported, there is somebody who is a victim of the fraud, and he says he has suffered some kind of a loss. Then we have some idea about how the fraud could have been caused, and we may even have a suspect. So the fraud examiner will have to look at the modus operandi of how the particular fraud would have occurred. This is a common scenario, and we are looking at whether the upcoming privacy regulations become a sort of a hindrance to the way the fraud examination society, or let us say the profession, has been developing. There are, of course, situations where the fraud examiners or the activity of the fraud examiners and their expertise is used as a preventive measure, that is to prevent a fraud from happening. And sometimes the fraud examiner will also may have to do some intelligence work, because prevention of a fraud includes detection of the probability of the fraud. Now, this means that in some cases, fraud investigation happens when you have a victim or let's say suspect. Now, the suspect is also told that we suspect that you have committed a fraud, and the fraud examiner is called in. We are talking of fraud examinations. It could happen in two ways. One is within the corporate entity, and another is through the law enforcement. When the law enforcement investigates a fraud, they have got the statutory backing. So they have got more powers to do something, and even if there are other conflicting laws, they have powers to override. Whereas when we do fraud investigation within a corporate entity, outside law considers us as part of the common people. So we have to be very careful, because if we overstep our limits as a fraud examiner, we may be perhaps breaking some other law. And one such law with which we have to be very careful is this upcoming data protection law. Therefore, the fraud examiners of today need to be aware that there are other laws which could infringe on their freedom to conduct a fraud investigation, and I want to actually focus more on this. See, many times in fraud investigation, we take such proactive measures where we try to map deviant minds within our organization. Suppose I'm an organization with 10,000 people. I need to know that out of this 10,000 people, what percentage of people are likely to commit insider frauds. Of course, fraud experts say insider frauds are one of the major concerns, because outsiders somehow try to entice the insiders to get into helping them, either by actively helping them or by passively helping them by not maintaining security in a reasonable manner. This question actually came into the law also when I was working on this. Now you can say a historically important case called Umashankar versus ICICI Bank case, where the victim was a victim of a phishing fraud, but he wanted to actually prove that bank was negligent, and it was more the negligence of the bank which caused the fraud and loss to him than his own negligence. His negligence was that he trusted that phishing mail and he gave away his password. And why did he give his password? Because he thought the bank manager was asking him to reset his password for security reasons. If we had thought of that as a fraudulent thing, he would not have handed over the password. So his passing the password was out of a mental state where he thought he is giving it to the bank, whereas the banker's security system was so weak, and it was also not in accordance with the law. They were using a password system for entry into the banking system, whereas Indian law equates a signature with a digital signature. Signature is not equivalent to a password, and the bankers want to make their things easy. Technology people want to say that you can do things with a password, and therefore the banks were using password against the recommendation of Law in Information Technology Act 2000. And that question was raised, and the adjudicator of Tamil Nadu at that time felt that that is correct. It is the responsibility of the bank to actually secure the entry into the banking system. Otherwise, they should be liable. When it went to the appeal court, we also raised the issue that not following reasonable security practices by the bank is like a passive assistance to the fraudster. See, you don't put in your efforts and then say somebody has hacked it from Nigeria, then if the customer was responsible for phishing, this is not an acceptable responsibility, and that is what the court also agreed, and they interpreted section 43 subsection G of Information Technology Act as indicating that the lack of security in the banking system, as recommended by the Law of Information Technology Act, as recommended by the Reserve Bank of India guidelines in the Internet Banking Guidelines in the year 2001, then Gopalakrishna Working Group Committee recommendations in 2016, and now the Cyber Security Framework in 2017. All these things actually were considered as lack of due diligence, and therefore they felt that the bank had given a passive assistance to the fraudster to use a stolen password and forge into the banking account. Now, this is what fraudsters need to look at, in the sense that some of the common practices used by the high value technology users is not in accordance with the law. Now, when something goes wrong there, the fraudster should point out to the company that the fraud has happened because you have kept the doors open, or you have kept the doors closed but kept the French windows open. So how do you prevent a thief from entering the through the front, through the French windows? If you have done that, or if your security person is looking the other way when the fraudster is coming here, then that is actually a fraud which has been committed with the assistance of the security personnel. And this is what the court said in the case of Umashankar's case, and said that bank should be responsible. Now, morning somebody was mentioning about the 1.5 crore frauds which is happening in the bank. It is happening because bankers are allowing it to happen, and all of us are not holding the bank to the responsibilities. Don't get it wrong with that I am accusing the bank, but I am an ex-banker myself, so I know what is the responsibility of a banker. But today's bankers are running away from their responsibilities and pushing in technology for their convenience. At the same time, they are making the public actually pay for the technology related weaknesses. Today, software companies don't have any responsibility because they can issue a software with zero-day vulnerabilities. And if that zero-day vulnerabilities is used by a fraudster, then the customer is actually said that he is negligent. This is not a proper way of controlling the frauds. Now, I have been telling for a long time that if Bitcoin and cryptocurrencies are banned, then the incentive for cyber criminals to go for these criminals will come down drastically, because if they continue to do the crime, they will have to exchange the benefits through, let us say, a banking system. The traceability will be better, and therefore one of the reasons why cryptocurrency ban has to be implemented is to reduce the incentive for cyber criminals, cyber terrorists, and so on. But our bankers are enamored by the so-called blockchain. Now, blockchain is a distributed ledger, which is good in certain instances. But when it comes to passing of my check, I don't want my check to be passed through a blockchain system where the entire system of, say, 5,000 customers are approving this transaction. At best, I may agree that 2 officers, 3 officers of the bank should be part of a private blockchain. So terminology is sometimes the technology people use it in such a manner that ordinary people, which may include many bank members, think that technology is great. Now, for example, you look at the Punjab National Bank fraud, which is occasioned in a core banking system, which was not linked to the SWIFT system. Anybody knowing banking system will laugh if you say that I will actually create a network system where SWIFT system is not connected automatically to the core banking system, and I can send an email through the SWIFT system and transfer funds without getting that recorded in the core banking system, either for the margin amount or for the commission amount which Punjab National Bank should have got. And also that SWIFT system was allowed to operate without a bias linking to the network. Therefore, somebody sitting in the office of Nirav Modi could send out instructions which amounted to issue of letters of guarantee. Now, this is where technology people, and when this was questioned to the technology supplier, they said that we presented our technology and our technology was capable of linking SWIFT to the CBS, but the bank people said that linking is not required. So we let it go and configured it with a different system. I say that in that context, that particular technology person, the supplier of the technology, was not thinking of how they are endangering the customers of Punjab National Bank if the SWIFT system and this CBS system was being delinked. So in terms of fraud prevention, today, the technology people are not taking responsibility. They talk of innovation to the exclusion of the safety of the society. And the people who are in the organizations, sometimes they don't understand the implications. Now, it is in this context that when we look at a law like personal data protection requirement in the law, we need to see what does this law say about the work of a frauds examiner. Okay. Now, prevention of frauds, putting a person in 3 years jail and other things is already there in Information Technology Act. Now, what this new act is doing is, it is trying to address a risk coming out of the new thought process that privacy is a right which is to be protected as a fundamental right. But nobody knows what is privacy. So they have said, because privacy is a state of mind, we define it as a state of mind of an individual. Now, that individual may change his state of mind from today to tomorrow, and there are 130 crore Indians whose state of mind has to be captured in a law. So the data protection law, personal data protection law, cannot capture the 130 crores persons dynamic state of mind and convert it into some kind of a protective mechanism. So what they did, they said that any person who is giving a personal data to another person, you please give me your choice how this information should be collected and used or disposed, and that choice become the obligation of the collector of the information, and that is what we call today as data protection. So this new Data Protection Act also speaks about collecting the consent of a data principle and then adhering to that consent. So the responsibility of the data protection organization is to understand what is the consent given. The consent has to be given for a specific purpose, for a specific period of time, and only the information which is required to meet that purpose should be collected. It should be only retained as long as it is required for the purpose. These kind of things are considered as the data protection obligations. There is the security obligation which is associated with this, which says that this personal data which is being collected has to be made available only on a need to know basis to others, otherwise it will be an infringement. The difference between the earlier ITA 2000 and this personal data protection law is the penalty system associated with the lack of compliance of PDPA. Now, if you are not compliant with ITA 2000, then the liabilities would come only when a victim files a case either with the police or with the adjudicator. Until that time, you can merely do what you want. Whereas in the case of this personal data protection law, it's a proactive implementation of the compliance requirement, and one can be fined for not, for example, appointing a data protection officer, and for not even registering. Even if you are a significant data fiduciary and you don't register, the data protection authority can put you a fine. It can be 5 crores, it can be 10 crores, it can be 100 crores. Earlier, we used to calculate the maximum penalty based on a percentage of the global turnover. Now that global turnover concept has been omitted in the latest version, but there is at present no upper limit on the penalty which can be levied for data protection infringement. And in fact, there is a precedence in the global scenario where Amazon has been fined $800 million as a fine. So we don't know. Indian Data Protection Authority may tomorrow think that XYZ bank has to be fined, say 500 crores, 1000 crores. Today, for KYC failure, RBI doesn't go beyond 1 crore, 2 crore, maximum 5 crores. Okay. Whereas our IPC still talks of thousands. Okay. Any fine, it will be 5,000, 10,000. So it is not a deterrence at all, but this will change. So this new personal data protection legislation will first of all introduce a commitment on the organization that they have to be proactively compliant with the law. They should not wait for a data breach to bring in the question of whether they were doing things properly or not. So the Data Protection Authority can conduct his own audits and then ascertain whether you are compliant with the law or not and look at the penalty. So therefore, the need for organizations to be compliant with the data protection law is very high now. Now, in that sense, if a company has to engage the services of a fraud investigator for investigating a fraud, then you have to look at what are the risks of engaging a fraud investigator. Now, what are the risks? Now, a fraud investigator is brought in to find out the truth in a particular transaction. He goes on digging for truth, and if he is using forensics, he will use so many forensic tools to understand what has gone behind. So the essence of fraud investigation is digging for truth. Now, what is the essence of privacy? Privacy is giving a choice to an individual saying that my information should be hidden to the extent it is not necessary to be given away. Some information I will give it away because I require it for the purpose of, say, taking some service from you. That is like if you want to go and use, say, Zomato services, you give whatever information they want. That is the permissions which you normally give for apps. But beyond that, information is still being collected. See, otherwise, how do you expect a Zomato IPO to be sold at a premium of 100 and odd rupees when it has got an accumulated loss of 20,000 crores or something like that? Now, today, all IPOs of startup companies, highly innovative, they have accumulated losses running to thousands of crores, and people are buying that IPO at a premium because people know that this either Zomato or XYZ company has a lot of personal information, and that personal information has got value. Though it has not been declared in the prospectus, there is a value. People in the banking system are aware that there was a company called CIBIL to which all bankers dumped their sensitive personal information of their clients. They had 500 million sensitive personal data sets of Indian citizens involving financial transactions. Now, earlier when CIBIL was formed, it was actually owned by the bankers of India to the extent of 90% or something like that, at least 80%. Now, today, if you look at the shareholding of this CIBIL TransUnion, 90% is held by an American listed company, not Indian bankers. Now, which means that 90% of the value of this personal data, which I had once said that it is worth about 7 lakh crores of rupees. Perhaps that is higher than all the NPAs of the bankers put together. 7 lakh crores rupees worth of data was transferred to a foreign company because they bought the 90% shares of that particular company. And who are the persons who transferred the shares? They were all our bankers, the public sector bankers, like the State Bank of India, like the Canara Bank, like another bank. You can see the list of these banks who had the shareholding prior to this. And now, okay, it is there in my site naavi.org if you make a search. Now, that is because the personal data which was held by this CIBIL was valued at zero when the merger or acquisition was worked out. That is the reason why I am personally working at the Data Valuation Standard of India and trying to force people to bring the value of data onto the balance sheet. Let it be there as a contra item, let it be there as a footnote, but let the shareholders know that my company has this much of personal data, and if there is an acquisition or any other issue, there has to be some way of valuing this. This is like scrap in a metal industry. It has got its own value. Now, the fraud investigators, therefore, need to be aware of the nature of data as an asset, the nature of the regulations which actually give a difference in the value between ordinary data, personal data, non-personal data, personal data which is a sensitive personal data. These are all having different valuations. And also there is what is called a depth of data. Some data is only name. Some data is name and email. Some data is name, email, along with that, let us say Aadhaar number. The values will have to be different. Now, when you are into a fraud investigation, you have to look at all those things. But the risk to the fraud investigator is when you get into digging the truth, sometimes truth which you would have felt it is better it would not have come out, will come out. For example, you are investigating fraud of Mr. A for an offense B. Now, when you go into investigation, you will find that Mr. A has committed not only this fraud B, he has done 10 other frauds. Now, as a fraud investigator, what is your contract with the company? Have you been assigned the contract? Please investigate fraud B, supposed to or suspected to be conducted by A. If in the process you have unearthed information which gives possibility of 10 other frauds, now what is your ethical stand? Should you tell that to the your employer or whoever has employed you, or that fraudster will tomorrow go to the court and say, you were a fraud investigator for offense B. I had not done that offense B or whatever is that, he has got a defense for that. but he may be caught for offense C or D. He may say that I was caught in offense C or D because this fraud investigator did not protect my privacy. So I will try to claim my own compensation for that. So the question of ethics comes here, that if the fraud investigator comes across information which is outside the contract of the fraud investigation, how should he handle it? Sometimes this is not only the information of the particular person. While you are investigating Mr. A, you get information about Mr. B. He may be a totally unconnected person to this fraud investigation with which you are dealing with. Now, is there ethics regarding that? Whether disclosure of that information is different from disclosure of further frauds from the person to whom you are commissioned to investigate? These are the issues which you need to sort out when the data protection law comes into being. Now, whenever a fraud examiner gets into an act, obviously there will be a contract between the company and you. In the data privacy law, we recognize certain roles like a data fiduciary and a data processor. Now, where are you standing in between this as a fraud investigator? Now, you are doing the fraud investigation at the instance of the data processor, so you are an agent of the data fiduciary, and you are therefore an agent of the data fiduciary. So all your liabilities should belong to the data fiduciary and not to yourself, provided your contract specifically says so. That is, the contract should have an indemnity which actually makes the fraud investigator not liable to the privacy infringements which may arise accidentally because you are digging for truth. Now, the data fiduciary has to understand that when he engages the services of an external person and then hands over certain personal data to him, he is putting that external person in the shoes of a data processor. And the data fiduciary has to tell that data processor, these are the limitations, these are your powers. If anything else is there, you please come back to me. But otherwise, any information generated during the process of your investigation, you are as much responsible as me as far protection is concerned. If tomorrow somebody hacks into an investigator's computer and gets the information about the company which he is going to, which he is in the process of investigation, that is also a data leak, and that data leak will be held against the fraud investigator more than that of the data fiduciary, in case the data fiduciary has taken steps in building a proper contract. Now, this is therefore a risk. Now, how does the law talk about this risk? The law actually gives some kind of exceptions within itself for the data fiduciary to engage in this investigative aspects. There is one section 36 in the new regulations which says that accepting security, other aspects of obligations, which is there is something called consent. Before getting a consent, you have to give a notice, and the notice should also protect certain rights of the data principle. That is data minimization, data retention minimization, all these things are there. But accepting security, everything else may not apply in the event of an investigation, particularly if the investigation happens to be a law enforcement official. There is no doubt. If it is done by an organization, then as a part of its information security obligation and as a part of the fraud prevention, part of the whistleblowing requirements, part of public interest, there are certain exemptions built into the information to the data protection law. So as a fraud examiner, you should know what are all the exemptions, and you should be able to ask the question to the person who is appointing you, that are you appointing me along with all these exemptions? That person may say, I don't know what is Data Protection Act, because there have been many companies in India who never knew that there was Information Technology Act for at least a decade after it came into existence. Until 2011, after the 2008 version came, many companies did not know that the act was already passed in 2000 October. So Data Protection Act will come, for example, from say next month, but it will become effective after 2 years. But it will take that much time for companies to even recognize the existence. But in the meantime, if you are undertaking any responsibility which can touch a personal data in the hands of your client, please ensure that in your contract there is a clause which says that you are only a data processor working under the contract of the data fiduciary and not to be treated otherwise. Because in the law, what happens is, if the data fiduciary has asked you to do something, okay, about which he is aware of, he will say you have to investigate the fraud. Beyond that, he will not say. Now, what is the process by which you do the fraud investigation? It is your proprietary knowledge. You may use some kind of technology for that purpose. You may use some tools. I will just take another few minutes. Okay. So you will take your own, you use your own tools. And if you say that this is my proprietary information, I would not like to tell you how I am doing the fraud investigation, but I am doing it. Then you take on the role of a co-data fiduciary, or in GDPR context, we call joint data controller. So as a fraud investigator, when you write the contract, ensure that you are not a joint data fiduciary, you are only a processor. And otherwise, you have an indemnity clause saying that for all the data protection requirements, the organization is responsible. Otherwise,
sir,
data, yeah.
Sir, sorry to interrupt, sir. So yeah. Can you, summarize your closing points? Like,
yeah. So in this context, what I am trying to highlight for the fraud investigating community is that you must understand that Data Protection Act will impose certain responsibilities on you, and the only control you have to do for that is through the consent format or the contract format. So please take a look at your contract formats now and ensure that your interest is protected. Other than this, you have to study what is there in the Data Protection Act in detail and understand what is called a harm, what are the sensitive personal information, and so on. So I will stop here. In case there are any questions, I will try to answer.
Sure. Any questions? Otherwise, we can also send a mail to him and get your answers. But do you have any questions now? Anything? Yeah. Yes, sir, please.
I'm not able to hear. If you can actually try to.
1 second, sir. He'll be asking the question.
Can you hear me now?
Yeah, I can.
In the context of the GDPR, you have explained certain precautions that needs to be taken in the Data Protection Act. Particularly now, the lot of contracts getting entered into by the corporates in the cloud scenario. So what, in your view, more so because everything will be the cloud scenario going forward. So what sort of a legislative intent the data protection is going to give, particularly in the wake of audit and so on, or the investigations part of it?
See, audits are to be done mandatorily once in a year. Okay, data audit mandatory once in a year for significant data fiduciaries. Okay, that is important, and that has to be done by an external auditor. Now, this is a data audit, not a financial audit. Beyond this, there has to be concurrent audit throughout the year. So this is what is said about the audit, and not doing this will become an infringement. Okay, what is the other point which you mentioned? You mentioned one more point.
No. What sort of a protection?
Protection for cloud and other things. Now, as far as the cloud is concerned, please remember that there is a data fiduciary who takes on the first responsibility for determining the purpose of processing and means of processing. And he gives that notice and collects the information. So he is primarily responsible. Now, if he decides to use ABC as his cloud service provider, that cloud service provider becomes a processor for this data fiduciary. So this data fiduciary has to ensure that the processor is bound by a contract, data protection contract, in which all the requirements, including your data localization, if any, or anything like that, should be transferred to the cloud provider. So there is no separate law required for that. Current law itself says data fiduciary is responsible. And that is why I am saying that avoid a situation where the next person becomes a joint data fiduciary. So as long as our contract ensures that I am not a joint data fiduciary, I am only a processor, my responsibility will be less. That applies to cloud users also.
Thank you.
If the cloud user is a big Amazon and I am a small company, you have a practical problem, but that is something which you have to handle. Say you are the person who is giving a contract to the Amazon. Amazon has to be bound by your requirement. So in many cases, for example, Amazon has got a separate service for HIPAA compliance. Likewise, we should ensure that Amazon will have a separate service for Indian PDPA compliance. Then you use that service. They may charge more or something, that is left to them. Now, GDPR compliance, Amazon would be happy to provide that service if you ask that question. They may say that if you don't want any GDPR compliance, I will charge you this much. If you want GDPR compliance, I may charge something more. Same way, they may also come up with differential services for protection of data. Okay.